You were arrested for drug possession. Now your attorney mentions PC 1000 or Penal Code Section 1000, drug diversion in California, and says there might be a way to keep this off your record entirely. You have no idea what that means, but you are listening closely because a conviction here could affect your job, your housing, your professional license, or your immigration status. Penal Code Section 1000 is one of those most underused tools in California criminal defense, mostly because prosecutors do not really advertise it, and most people never know to ask for it. I'm Nana Knight. I'm a criminal defense attorney in San Jose, and in this video, I will explain exactly what Penal Code Section 1000 is, who qualifies, what the process looks like, and what happens if you complete it or if you do not. PC 1000 refers to California Penal Code Section 1000. It is a drug diversion program that allows certain people charged with low-level drug possession offenses to avoid a conviction entirely by completing a set of requirements. And here's the basic structure. Instead of going through a full criminal case, your case gets deferred. You basically complete a drug education or treatment program, you pay the required fees, stay out of trouble for a set period, and when you finish, the charges are dismissed. No final conviction on your record. That is a significantly better outcome than what most people expect when they first see handcuffs. So let's talk about who qualifies for PC 1000. The program is designed for first-time or eligible repeat offenders facing charges related to personal use only, not sale or distribution. Generally, to qualify, you need to be charged with simple possession of a controlled substance, have no prior drug-related convictions within the past 5 years, have no prior PC 1000 or Proposition 36 diversion within the past 5 years, and have no history of violence in the current case, and not be facing charges involving sale, transportation for sale, or a weapon. If you meet these requirements, you are likely eligible, but you need to talk to your attorney to ascertain your eligibility. Your attorney makes the formal showing to the court, and the case is placed on the diversion track. So the difference between PC 1000 and Proposition 36, let's talk about that. A lot of people confuse these two programs, and the distinction actually matters significantly. PC 1000 is a pretrial diversion program. In the current PC 1000 cases, you generally plead not guilty, you waive your speedy trial, preliminary hearing, and jury trial rights, and the court may grant you pretrial diversion. If you successfully complete the program, the court dismisses the charges. Participation in PC 1000 pretrial diversion does not constitute a conviction or come in as an admission of guilt on your record. So if you're successful in a program, you walk away with no conviction on your record. Proposition 36 is a post-conviction probation based on a treatment program for eligible nonviolent drug possession crimes. You plead guilty or no contest first, and then you enter into a drug treatment program as a condition of probation. Now, if you successfully complete treatment, the court can dismiss the charges. But there was a guilty plea already entered under Proposition 36, and that matters. From an immigration perspective, and for many professional licensing and employment background checks, PC 1000 is almost always the better outcome because there's no plea on record. You don't have to plead guilty or no contest to the charge in order to participate in the PC 1000 diversion program. In Prop 36 cases, a conviction becomes final if you fail. For immigration and licensing purposes, the distinction is significant and the specific outcome depends on the facts of your case. If you or someone you know is not a United States citizen, this distinction could be the difference between a path forward and a devastating immigration consequence. So talk to a qualified attorney before agreeing to any resolution, including diversion. What does the PC 1000 process actually look like step by step? So step 1, your attorney identifies that you qualify, you're eligible, you're suitable, and makes a showing to the court. The judge then looks at the evidence presented and could grant you that diversion. Your case is placed on what is called a pretrial diversion program. Step number 2, you receive your conditions. These typically include completing a licensed drug education or treatment program, paying the program fines and fees, and checking in as required, staying crime-free, arrest-free during this deferred period, which is generally up to 18 months and sometimes requires regular drug testing. Step number 3, at the end of the diversion period, if you've completed all the conditions as you were ordered, you come back to court and the charges are dismissed. Step 4, after your dismissal, your arrest is deemed to have never occurred, and the court may order your arrest record sealed under California law, which can further limit what shows on your background checks. This is not a free pass. You have to complete what is required, but if you do, you walk away without a drug drug conviction on your record. So let's talk about who qualifies for this drug diversion program in this context. Now, PC 1000 covers a broad range of controlled substances, including marijuana, cocaine, heroin, methamphetamine, prescription drugs possessed without a valid prescription, and many other controlled substances under the California Health and Safety Code sections. Simple possession of marijuana has its own separate rules under California law since adult recreational use became legal in California. But possession of larger amounts or possession of other substances or possession of circumstances suggesting sales can change the analysis significantly. So what happens if you fail to complete the terms of a PC 1000 grant of diversion? If you violate the conditions during the deferral period, whether by picking up a new arrest or failing to complete the program or failing to appear as required, the pretrial diversion can be revoked. That means the case comes back to regular criminal prosecution, the criminal proceedings are reinstated, and you could end up facing the original charges as if the diversion opportunity never existed. And this is why it is critical to take the condition seriously, to communicate with your attorney immediately if something comes up during the program that could jeopardize your completion. Does PC 1000 show up on background checks? After successful completion and dismissal, the charge should not appear as a conviction on most California background checks. However, the arrest record itself may appear on some databases before a sealing petition is granted. Federal background checks, immigration-related checks, and checks conducted by professional licensing boards can sometimes surface information that does not show on standard state checks. The specifics do vary by profession and by context in your case. So if you're a teacher, a nurse, or real estate professional, for example, or a contractor, an attorney, or anyone subject to a licensing board, have a specific conversation with your attorney about what that resolution means for your license before agreeing to it. Do not assume that because it ends in a dismissal at the end, if you're successful, that it's going to automatically basically not appear on your record for every purpose. So who should be talking to their attorney about PC 1000 right now? Anyone charged with a simple possession in California as a first or eligible offense should be asking directly whether PC 1000 is available as an option in their case. If your attorney has not raised it, you can ask, am I eligible for PC 1000 diversion? That is a legitimate direct question and you deserve a clear answer. For people in the Bay Area in California and throughout Silicon Valley, this matters especially for those on H-1B or other types of temporary visas, for students who receive federal financial aid, for people with professional licenses, and for anyone for whom a misdemeanor conviction could close doors that are difficult to reopen. A drug possession conviction in California does carry collateral consequences beyond the criminal penalties themselves. It does and can affect housing applications, certain employment categories, and professional licensing in ways that are far longer than the sentence. So PC 1000 was designed specifically to give eligible people a path to avoid all of those consequences. The short version of what I just told you is if you're charged with a drug possession in California and you have no prior drug convictions within the last 5 years, there's very likely a path to get the case dismissed without a conviction ever being entered on your rap sheet or your record. The key is asking the right question at the right time. So have you or someone you know dealt with drug charges in California and wondered whether diversion was an option? Drop a comment below. Tell me what happened. I do try to read every comment and I will try and respond. Now, if you want to understand how California expungement and record sealing works after a conviction or a dismissal of a criminal case, I have other videos on this channel covering those topics. And if you're facing drug charges in San Jose or anywhere in Santa Clara County and you want to speak with an attorney, you can call our office at 408-877-6177. PC 1000 eligibility depends on the specific facts of your case, so do not assume you qualify or that you do not qualify without speaking with an attorney. So what questions do you have about drug diversion in California? Drop them in the comments below, and as I go through them, again, I will try to answer.